All rise. The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in McCoy versus Rosebrough, our case number CV21 0676. Each side is allocated 20 minutes for oral argument. The appellant may reserve a portion of your time for rebuttal. If you wish to do so, you're free to do so, but you'll need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid any embarrassment, I would ask those in attendance to make sure your cell phones are off or on vibrate. We've read the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube. Accordingly, as you begin your argument, please state your name and the party you represent. With that, Mr. Woznowski, and I always mispronounce that, so I apologize.
May it please the court. I'm Mike Wierzinski. I'm here for the appellants Sharon McCoy, Marcy Johnson, and Melissa Wilson-Scoble. The reason we're here today, and I know there are several different appeals, so I know you're likely familiar with the one most recently issued, the only one issued out of the series of these that come out of the trial case. And I suspect we'll talk about that and some differences and how we're approaching some of the claims based on that at this point. But the reason we're here today is essentially my clients are private citizens in a private community who voluntarily, for no pay, ran for a position on an HOA board that ordinarily doesn't excite the public imagination and ordinarily doesn't have enough people to even run for it. Here, what occurred, as alleged in the complaint, is that the defendants, two appellees among them, created an atmosphere that created a controversy to which my clients were compelled before they ran for the board. Respectfully to the trial court, and the trial court's done a yeoman's job of administering the case and ruling on things and so, but respectfully, we think the trial court erred in a couple of different ways. First, we think the trial court erred in determining that the test was the heightened scrutiny test available for public figures, period, and limited public figures. And we think the court erred in two ways, both substantively. The first way was that the court failed to distinguish between the characteristics of primarily private organizations that come into the scrutiny of the public at large based upon the acts of certain individuals using primarily social media. Admittedly, we're in rarefied territory in many regards here. I haven't heard anybody disagree that the multiple motions have been filed and the briefs that have been filed that before the decision in McCoy versus Lindsay was rendered, there were no Arizona cases talking about HOA boards and whether the people who run them are public figures or not. We now have the benefit of that case and acknowledge, although I will note, I've done a considerable amount of research in the past few days trying to figure out exactly, I understand the mandate rules. I don't know that I fully appreciate the rules, and admittedly so, I'm a rare guest at the Court of Appeals. I don't think I fully understand the rules of what emphasis that has on courts, other Court of Appeal courts, different departments, or even the same department in rendering decisions with regard to different parties. If it's out there, I didn't find it, and I apologize. I did look for it. But, so while acknowledging that, and obviously not in these briefings, in subsequent briefings, and commenting, I think, appropriately regarding the same, we haven't done so here. But during the course of this, I suspect we'll, like I said, we'll discuss that.
Well, do you want to address kind of that elephant in the room that there's been a MEM decision made in parts, other defendants in this case? How is this different And why should we turn left and do something different than what we've already done on these particular defendants?
I think that's a fair question, one I've given, as you might guess, some thought to. The answer is yes, you should view this separately. They were brought separately because of different procedural issues and different things that went on in the trial court. Most notably in this case, there's a procedural wrinkle, two of them really. And again, one relates to the substantively, for which we're asking for a reversal and remand, has to do with the court's determination to resolve both these cases without providing appellants a sufficient opportunity to provide a response. We didn't get that opportunity. The decision was rendered. The second, and maybe more importantly, is the court in discussing whether these statements were capable of being rendered as defamatory, not whether they in fact had a defamatory meaning, seemed to apply a heightened standard to that test, for which we respectfully disagree. We don't think there's a heightened test for that, and we think Yetman, Druk, and the Mraz case all stand for that proposition. We believe
Counsel,
that... I'm
before
sorry,
you go on, I'd like to come back to Judge Bailey's question, and I think just to put a fine point on it, do you agree that these are, for purposes of these cases, limited public officials? Or are you disputing that, and if you are, why?
Well, I'm continuing to dispute it because of that appellate procedural angle that I don't know the answer to. I want to make sure we don't waive it, but I also want to give the proper respect required, and that I believe I've tried to abide by my entire career, which is the courts make the decisions. We make the arguments, the courts make the decisions, you respect the decisions, whether you take them or not. But
Where do you think Hassan went wrong then, in the public official discussion? Is there any place that you go, that's where the error is?
I'm sorry, Your Honor, I missed
In the Hassan decision, where would you say the Court of Appeals went wrong, and that's why we should turn left on the public official analysis?
And I apologize,
It's the other McCoy, it's the
Oh, the
case
other-
that just,
the-
right,
okay.
it's the other.
Hassan.
Right.
Yeah, I'm sorry, if I mispronounced, I apologize.
You're fine.
The other case.
I went to Price Club and had a hearing test, and they tell me I'm fine, and I don't believe them. But at any rate,
And let's just stipulate that whatever you're saying is with all due respect. Like, I get that
Okay,
that I'm sitting right here, and that's fine. We need to know what your opinion is of that, because you've taken a little peek behind the curtain. So what would you do now that's different?
I would argue that what makes this different with respect to Ms. Johnson is that her communications came well after all the elections and circled back to old debates and old discussions during the time any of our people were on the board, and that it was remote in time. We cited two cases in our briefing, the Duché case and another California case in the same area, discussing, look, there has to be a time at which people who were limited public figures stop being limited public figures. And to simply make more statements about them later without some kind of context saying these were relevant, pertinent to the discussion, et cetera, should render them back to their private person status. That's not true with respect to Mr. Rosebrough. All of his statements were made within the context of running up to the election or between the election. I believe they were all before the election or something.
And should it make any difference if you're referring to acts they took when they were? If we say, if just assuming that we are calling them limited public figures, does it make a difference whether those later communicated messages are made about that person in that role or outside of that role? Are you never, once you leave that status, are you never allowed to go back in and talk about that person's role while they were in that status, or else it could be defamatory?
Well, I think that the test is announced in the cases that we cited that there's a multi-pronged facet to them. One is the timing of it. That's the primary consideration there, is that these happened after. And so where is there evidence in the complaint or in the record that any of the conversation was relevant to anything else going on? There is none. So at this stage, I think you have to make a presumption that it isn't relevant. But because, there's motion for summary judgment stages and trial stages that would follow. However, I think, or not however, in conjunction with that, the statements themselves talk about much older things. So in short, I think there's a line to be drawn. Now's not the time to draw it.
So what do you mean the statements talk about much older things? Because I'm not sure we have the statements themselves really in the record. So which statements?
Well, you have the allegations of the statements, and that's what, at least with respect to Ms. Johnson, that's what you have in the record. That is the record. The statements were never attached, despite claims.
So what are the allegations of the statements that would lead us to conclude they were about something before she held office? Or as part of her holding office?
Yes.
What is it?
Let me turn to them. Well, you wouldn't be able to know that, but the part of the statements that were alleged have to do with a management committee issue that occurred in a much earlier preceding election, or up to a much earlier preceding election.
What do you mean we wouldn't know that? Meaning it's not in the
It wasn't in
record?
the complaint, and it's not in
Right.
the record.
And is that an issue? That a trial judge is looking at a complaint that doesn't actually spell out what the statements are? I mean, you read this and it's kind of a summary of statements, and here's what I believe they meant. But we don't have a complaint that says, this is what was said.
Well, I'd have to leave the record to tell you why that is. We didn't have the statements, frankly. We have snapshots of some of the statements. My clients weren't in these social media contexts to respond or do anything, and that was alleged in the complaint. They were getting screenshots from others saying, this is what people are saying about you. So that's where those statements come from, and they're fair. I would represent to you, they're fair allegations and summaries of the statements as they appeared with the quoted language from them that we used.
Counsel, let me ask you, you have essentially said, although let me make sure I understand this, that a limited public figure ceases to become a limited public figure at some point.
Yes, right.
And I think, just from my notes, one of the distinguishing topics is, were statements made before or after a certain event, right? Although, help me if I'm misconstruing that, but I thought I heard you also say that timing matters. So even if they were made after, if they were made 20 years, say, after the event, that might have the limited public figure time may have ended by that. Is that one of your points?
Sure, I'll give you a more concrete analogy relative to this case. There was a recall election, if my memory serves, June 1, 2020. If on June 2, people made statements to the effect that on this date, we won their, whatever the statement is, that could be, if your determination that they're limited public figures, then that could still fall in that context. I wouldn't argue that the moment something of as a quote decides, controversy is over, that's it, you can never talk about it again. What I'm suggesting is that line drawing is terribly fact intensive and shouldn't be a moment on a motion to dismiss. I mean, it should be enough to say, look, this stuff came after the recall election, which is what we alleged, and alleged what those statements are, and without anything else in the record, how could you draw the line? And I guess the other question is, or is it incumbent upon us under Rule 8 to flood that? I don't know. We struggled mightily. We have a rather large complaint already that I was concerned about Rule 8.
And help me, what's your best case for the proposition that that's a Rule 56 issue, not a Rule 12 issue?
Well, in several different regards. One, again, if we knew the dates that these were sent, or we had them, we would have provided them, or at least provided the dates. I mean, that would have been something relevant to allege. We didn't have them. We had snapshots of them, and we could kind of tell from different dates different things were happening. That becomes one of the issues. In terms of what would make it a Rule 56 proposition, in legal terms is were these communications in isolation, or were they being exchanged, giving honor to the ruling that's already been made, were they in the relevant context still? Those are things that have to be factually determined.
Well, and my question was really what currently existing published opinion case is the best case supporting your proposition that this should have been summary judgment material, not motion to dismiss material?
I think Yetman would be on point in that discussion, and let me look at my notes. I think Yetman has an extended conversation, primarily not on that issue, but I believe there's some discussion about the context is very important. That we did cite the 2 California cases for the proposition that even in the SLAPP suit context, that time and place and content are all important.
Although it strikes me that SLAPP suit cases are somewhat different than what we're being asked to address here. Would you agree with that?
I think by the volume I wrote about it, I think I have to say yes, right?
Just want to make sure we're on the same page. Okay.
Sorry.
Thank you.
Hopefully at my expense.
No, that's fine.
Your Honors, again, I had a different preparation before we got a decision. The decisions actually kind of help move some of it along. I'm pleased to answer any of the other questions. I guess I would direct you to the issue that I raised here that wasn't addressed in the earlier decision was the judge did, we believe, and I think I'm repeating myself and I apologize, the judge did use the wrong standard, applied an elevated standard to determining the factual element. The other thing that's unique to this case is the statements are unique. So just because the statements in the Hassan case were determined to have lacked a defamatory capability, it doesn't mean the same applies here. Clearly, the court's articulated the standards for that. Unless I don't have any particular criticism of the standards in that regard. And so I'll preserve the rest of my time, if I may.
Very well.
Thank you.
Thank you, Counsel. Mr. Wilson, Mr. Brown, how are we going to do this? I see you both signed in. Okay. I'm happy to have you allocate your time as you wish, but collectively you have 20 minutes.
Understood. Thank you. Good morning to the court. Darrell Wilson, appearing on behalf of appellee James Rosebrough. Judge Bailey, I believe you were on the prior panel in the prior.
I believe I was.
And I believe you wrote the opinion.
I believe I did.
And so, obviously, on this side of the room, we agree with that the opinion and the characterization of them as being public figures, and that the requirement of malice be necessary to prove defamation. Does the court have any question that relates specifically to Mr. Rosebrough and whether or not they were not public figures? I don't see any, but I just wanted to address the court if the court had any concerns about the plaintiffs being public figures related to Mr. Rosebrough.
I think we understand your position, Counsel, from your briefs.
So I'm not going to make any comments on that determination. I just kind of want to go to the actual allegations in the complaints. They're listed on page 12 of the opening brief, and Mr. Wierzinski, I believe, addressed the issue of timing, and that Mr. Rosebrough's comments all came before the election or leading up to the election. Point one was that in a letter accused Marcy of conflicts of interest, as well as accusing non-party of Todd McCoy regarding conflicts of interest. In a meeting, falsely stated that there was in a board meeting, a social media post which kicked off the recall campaign, and there was a statement actually quoted there, which, although it's truncated and broken up. And then 3, a leaked letter to Cher, that Cher wrote to the board about a community member. And the thing about it is that, number one, when you have to plead a defamation, a statement with some level of particularity, there's no allegation of what Mr. Rosebrough actually said in the letter to the board about Marcy's conflict of interest. There's no quote in here that he even said conflict of interest, and the letter's was not attached as an exhibit to the complaint, which frankly is a pretty easy thing to do, which would then incorporate the contents of the letter. And I didn't find anywhere in the record where the contents of the letter was actually produced by the plaintiffs related to this allegation.
Counsel, was there a motion for a more particularized statement filed?
Not from my client, no. Now, the other 2 statements, I believe, based on reading of the brief, I believe that plaintiffs have waived those statements or have waived the argument that they're defamatory. But again, statement number 2 it relates to a meeting with the board. So this is a board meeting with board members where he's making this statement. And then 3 is the letter is actually written by Ms. McCoy, and so it can't be defamation if it's her own words. Whether or not it was a nice thing for him to leak the letter, or if he even leaked the letter, that doesn't relate to the defamation. It's what the words were said. And part of the, when you're talking about public figures and, issues of public controversy, the first two points, the letter and the meeting of the board, that's the board meeting and discussing board business and issues before the board. And I can't find any case that has any kind of qualified immunity for board members during meetings, but it's clearly political and it's clearly addressing issues which take it out of the realm of defamation. It also, there's nothing pled related to any of these that establishes any form of malice.
Counsel, let me ask
Sure.
you, I have a related but different line of questioning. It strikes me that in the dismissal of the claims against your clients, they got more than their motion to dismiss requested. I think the motion to dismiss was on the Fair Housing Act and the private nuisance claims, but the court dismissed, with the exception of one of the claims against Jennifer, all the claims against your clients. And that seems to me a little irregular if you look at the procedural requirements for a motion to dismiss. So help me understand your argument on that point.
Sure, Your Honor. So there's, I don't know how many motions were filed. All of them argued different things. There was over a 2-hour oral argument. The transcript was provided. There was significant discussion at oral argument where plaintiff's counsel had the opportunity to argue regarding the sufficiency of the claims. And defamation and defamation statements are a little bit different than your standard allegations. And I believe it's the Yetman case that specifically says that the court is to be the gatekeeper and to make sure that these frivolous claims don't get filed. So, while it wasn't briefed in the brief, it was discussed and dealt with on oral argument. And I understand that, appellants have made the comment that they didn't get the opportunity to brief it, but we do have remedies for that in the rules of civil procedure. It's called a motion for reconsideration, or it's called a motion for new trial. And it would be simple to have cured some of these things if the allegations are actually there, to have requested a new trial and submitted a proposed amended complaint stating that, if given the opportunity, we would amend as follows and these would have cured the defects. But I don't even think they argued that an amended complaint could cure the defects.
Well, and I understand what you're saying, but my question is really more basic than that. A motion to reconsider it think, sort of assumes that an original motion had been made and it was granted, and you're asking the court to revisit that. As I see it, other than the Fair Housing Act and private nuisance claims, that was the extent of your client's motion to dismiss, right?
The written, yes.
The court sort of went further than that in the dismissal order, and that's the gap that I'm asking about.
Yeah, I mean, there was, it's, in the transcript, it discusses the joinders in the motions, and the court basically looked at it as being one gigantic motion, I think.
Did your clients join other motions to dismiss on the other claims then?
Not in written form.
Okay.
If I can just follow up, because earlier you made just an offhand comment. I don't see that you argue that this is political speech, but you mentioned political speech. Are you arguing that this is protected political speech, or is the limitation simply the result of their limited public official status or person status?
Yeah, I'm not arguing, because it wasn't briefed as political speech, but it is dealing with a political controversy at the time that's relevant to that community.
Thank you.
So that, yeah, thank you for letting me clarify that for you. And then just to follow up, and then I'll conclude my remarks. The statements to the board, there's an argument made that there's a statute that requires disclosure of a HOA board member of potential conflicts of interest when they run. And appellants appear to be arguing that, like, well, because of the statute, you can't then later question that they have a conflict of interest. Of course, the problem with that is that if the court were to hold that accusing a board member of a conflict of interest after they've run and after they didn't disclose a conflict of interest pursuant to the statute would basically open any board member or any resident in the community to a defamation claim if they simply allege, like, hey, I think you have a conflict of interest related to this other business you're running. So that again shows that, you know, and the simple fact that there is a statute that says you have to disclose your conflicts of interest show that there's a public policy related to disclosure of conflicts of interest, and that conflicts of interest are a matter of public issue amongst when running for a board of an HOA. And I'll turn it over to Mr. Brown. Thank you.
Thank you. Thank you. Mr. Brown.
Thank you, Your Honors. It's a pleasure to be here. I'm Nathan Brown for the appellee and defendant Leslie Johnson, who is here with us today. To start off with, we're here because of an HOA, and I think the timeline is important in understanding what went on here. Our contention is that plaintiffs Cheryl McCoy, Marcy-Ann Johnson, and Melissa Scoville, they ran an HOA as community sheriffs, and people in the community wanted them removed. The things that went on were so bizarre and strange that I think one day, and with the involvement of religion and the amount of lives that were destroyed, I think one day this will end up being a book. And it'll probably be written by author John Krakauer. This is one of the countless lawsuits filed by these plaintiffs against their neighbors. There's been a long history of it. It's in the trial record. There's never been a time in recent memory where the plaintiffs have not been filing lawsuits against their neighbors, either as board members as themselves personally. We are here because of two words. LDS handpicked. That's why my client Leslie Johnson is on appeal. They're claiming that is defamatory. Our first argument is that there's no standing. The comments were not about the plaintiffs, and even though they wanted to be the community sheriffs, they can't be defamed for comments that weren't directed towards them. As I mentioned, they were not on the board at the time. The comment, and it says plainly in the proceedings, they were not on the board. It was after they were recalled, and it was about the current board. And these comments are about Dustin Snow, who was an official in the LDS or Mormon Church at the time, who was choosing which candidates could run for the management committee. You'll see all the other comments, even though many of them are misquoted, are also about Dustin Snow. These are not about the plaintiffs.
Counsel, is that type of an argument one that's properly addressed on 12b-6 as opposed to a motion for summary judgment? What you're talking about is context for the statements alleged in the complaint, and it strikes me if the court needs to look at that kind of context, we need, it needed and we would need something more than a bald complaint.
Honor, I don't think so. I think it has to do more with the judicial restraint. If it's not about, to me, it's clearly not about the plaintiffs, if you take the plain language, and so that could be addressed on a 12b-6. And I think it says there, after the election, about the board, and the plaintiffs weren't on the board. And even if it was, the court held that these were opinions. They didn't hold that they had the heightened standard. They just said under the First Amendment, these are opinions and are protected speech. And I think we need to delve into these words. The words LDS handpicked. LDS stands for Latter-day Saints. And for those who don't baptize for the dead, a saint is a compliment. And if somebody were to call me saints, it's definitely not a derogatory term. It's an informative term, and it's a preferred term. And for them to decide, in fact, to go back, it's actually a redundant term because Latter-day Saints, handpicked. In order to be a saint in this religion, you have to, by definition, you have to be handpicked. You have to be handpicked from God. And so for my client to state that someone is a saint handpicked from God, we have no idea how that can be viewed as defamatory. And the argument, furthermore, the argument that they're limited public figures, the court didn't even address that with regard to Leslie Johnson. The court just said that they're opinions. These are statements of opinions. You can't go to a single election without, or in fact, any election, any appointment with somebody using the phrase handpicked. And for that to be defamatory in any way, I think we put in there that every day there's about 9,000 accusations against Biden for handpicking somebody. Every appointment, every election, there's the accusation of being handpicked. Sometimes it's good. Sometimes it's a good thing to be handpicked. Sometimes it's a bad thing to be handpicked. And sometimes it's neutral. It's imaginary language, which is also, I believe, is protected by the First Amendment from defamation.
So your point is that using the phrase handpicked could never, ever provide the basis for a defamation claim?
No, yes, and because it has more than two meanings, because LDAs or handpicked could have three different meanings.
And does that, let me expand that then, if a word could have multiple meanings, does that mean it could never provide the basis of a defamation claim?
Yeah, that's my understanding of, and I think I don't have the site, but I believe that's, the word has to have two meanings in order to bring it before a jury.
I'm sorry, I want to make sure I understand. Two, but no more than two?
If it has any more than two, then the standard, I believe we cite to this, is that.
Do you know where you cite to this?
No, sorry. I actually think it's in the trial court. That if it has more than two meanings, then then it can't be viewed as defamatory.
Okay.
Becomes imaginary or speech. But like I said, I don't even think we get to there. I think it's an opinion. I think there's no way, we are going to test to see how do we test to see if something's handpicked, right? How do we test if it's true or false that something is handpicked? I think that's too much to ask, and it's not the standard here. Let's see. And just to rebut some of the things council said, they said there's not enough people to run for the board. That's not based on fact. There's more than enough people. In fact, plaintiffs set up a system, and it's in the trial court briefings, where they stop people from running for the board, and that's one of the complaints, is that they rigged elections. They set up nominating committees where only their friends could get past that, and at one time, it was all one religion on a board, and no one else was allowed to run. And those are some of the accusations leveled against them, is the people of the community just wanted it to stop. But yeah, in fact, like I said, anyone who was openly critical to the board was not allowed to run. And so the only way to be critical of the board was to be online. And if you offered your opinion, you ended up in this lawsuit. And you ended up, as it says, with other times with cease and desist letters. And so all this did was chill the free speech in the community. I do want to hit really quick on the limited public figures. I think with the other side's definition of a limited public figure, that if you're part of a private organization, you can't be a limited public figure. I can think of so many cases where that's not true. LeBron James, because he is on a private Lakers team, cannot be a public figure or a limited public figure. Elon Musk, because he owns Tesla and it's a private company, cannot be a limited public figure. I think that the standard that Plaintiffs' Counsel has said is unreasonable in the public figure range. I also want to say that it's our position that the court has the right, sua sponte, to issue a 12b6, and that even if the arguments aren't brought up, the court can always do that sua sponte. And again, as the appellate courts, as you said in your appeals brief, a lot of these things aren't even about, they're snapshots and not even about the plaintiffs. And we ask the court to sanction them, and whatever the court will allow, because otherwise we've got 20 more of these coming to the appeals court. And really, in our opinion, enough should be enough. Thank you very much.
Thank you. Appellants do have last word. Yes, please proceed.
Your Honor, the context for Ms. Johnson's statements are alleged in the complaint. There's 3 allegations. It's the middle one. That's the one that we claim states a statement of fact, not opinion. And in terms of answering counsel as well, how do we know what anybody means if they say LDS handpicked? Well, after the recall, she referred to a Mormon person as we've alleged. She was evidently on a microphone. They claim she didn't know it. She made a derogatory statement about a different LDS person. In an earlier post before the election, I believe, she made a post about reflecting on people's religions, I think without naming the LDS religion, saying that that's a reason why not to vote for people. So I think you don't have to look far for some context to say, hey, if this is capable of being a factual statement, because this person has attributed that as a negative statement in the past and is using it divisively, that would demonstrate malice. But we're a step way ahead of the game. We weren't required to demonstrate malice here. The question is, if somebody says, hey, I handpicked them, or those people were handpicked to be on the committee, is that something capable of being demonstrated as true or false? And the answer is, of course it's capable. It either happened or it didn't happen. My clients say it did not. And that's enough to send this case back for Ms. Johnson. With respect to – Mr. Rosebaugh's counsel's arguments. The context for the statement concerning Marcy and it being defamatory, as counsel makes a good point. Of course, we should all be able to raise potential conflicts of interest people have. What we can say is, hey, they may have a conflict of interest. It could be a conflict of interest, not she has a conflict of interest. And why is that important here? We allege it in the complaint. Mr. Rosebaugh was on these boards at this time. He's not merely saying it as a member of the community. He's issuing a letter as a board member saying she's got a conflict of interest. That means something. Statutorily, it means something. What other could be divined than she's referring to the statute? We gave you citations, the context in which the claim was made outside Mr. Rosebaugh. What other people were saying about the conflict of interest, that's enough to send his claim back to the trial court. With Cher, I think I've left counsel confused, and I do that to a lot of people, and I apologize to them. We're not claiming defamation for Cher. We can't, right? It's her letter. She gave to the board. She didn't give it to the community. She didn't distribute it wildly. She gave it to the board, and Mr. Rosebaugh gave it something so it could be published to the community. It's not full of lies. It's full of truths. That's why we didn't say that it was defamation. It's a false late invasion of privacy. We'll send something to the board for the purpose of the board's review, not for the communities.
And if she's a limited public official, then it doesn't matter.
Then, as we said in, I think, in Hassan, in this brief, all of our briefs, if you decide she's a limited public figure in that context, then she doesn't have a claim. I think that's pretty self-evident. I'm out of time. I'm sorry. Thank you. I appreciate the opportunity.
Counsel, we appreciate your presentation today. We appreciate your briefing. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.
Thank you.